Afternoon. It's already the appointed time and we formed a quorum. May I call the meeting to order. Please invite the administration to join us now. Welcome to the meeting of the third meeting of the Bills Committee on Landlord and Tenant Consolidation Amendment Bill 2021. Present today, we have Ms. Dr. Raymond So, Undersecretary for Transport and Housing, Mr. Carlson Chen, Director of Special Duties, and Ms. Kathy Chan, Assistant Director on Tenancy Control on Subdivided Units. We've also got the Assistant Commissioner from the Rating and Valuation Department and also a Deputy Law Draftsman from the Department of Justice. On the 29th of July, we had our last meeting and we asked the administration to provide information on a number of items. The administration has provided its response in paper number 1190/02. And then the legal advisor has also written to the administration on the 28th of July and the 2nd of August, respectively. The administration has provided a reply dated the 13th of August in papers number 1190/04 and 05. We discussed the overall proposals in the bill at the last meeting. And the administration has responded to questions by members. I will now open the floor to members to ask questions of the administration. I will allow you to ask as many questions as possible. And I believe many members have already read the papers. So, administration, can you please walk us through the replies? On the 28th of July and the 2nd of August, we received letters from the legal advisor of LegCo respectively. And also on the 29th of July, members asked the administration to provide replies to a number of questions. We've already provided a reply. Now, in the letter dated the 28th of July, we already explained that the bill is in compliance with Articles 6, 25, and number 5 of the Basic Law. And in the letter dated the 2nd of August, the administration explained that there is no official or uniform definition for SDUs as regards the criteria used by the Census and Statistics Department in the 2016 population by census is different from what is used in the task force. For instance, for the 2012 and in the 2014 and 2015 surveys, SDUs were did not include bed space, etc. And then we've provided information on enforcement by the Buildings Department and also the number of SDUs. That's my overall response to members' questions. Thank you. 6 members have put up their hands. We have Mr. Michael Tian, Regina Yip, Tommy Zhang, Ronick Shen, and myself. All right, 5 minutes each to start with. Mr. Michael Tian. Thank you, Chair. I'd like to reiterate what I said at the last meeting. I have 3 concerns. First, and that is the cap on rental increase after the first 2 years. Many people, including the concerned groups, have come to us, and they whether it be the 5%，咁所以佢哋覺得。Would that be the rental increase index in the past few years, and they're of the view that the cap of 15% is without basis. And secondly, for those waiting for PRH, usually they have to wait for 5 to 6 years. And so what happens after a term of 4 years? So I hope that it can be 2 + 2 + 2. And would this really be a disincentive to investors? And my biggest concern is initial rent. Now, it's not just me. Many people have come to me on the same point and find it interesting. If the legislation doesn't regulate the initial rent, then it is really useless. Of course, you have difficulties in setting initial rents, but then you have to overcome the difficulties. If you say that the challenge cannot be overcome, then it's pointless to have the bill, because the market right now is free to set any initial rent, so you are not helping matters. The administration has no choice but to increase the level of living allowance, so that even those who are not living in PRH yet will continue to be able to afford rent, and the landlords will continue to raise rental. This is ridiculous. Now, I think you can use the valuation by the rating and valuation department. Although the rent levels may be very different for a while, but then if in the long term the rates or the rateable value is a far cry from the market value, what's the point? So I think you should peg the rent to the rateable value. Let's say we have a 1,000 square foot flat, and if the rateable value is about 20,000, then all the tenancies in this flat, you can have as many as you like, but the total rent charged must not be over a certain percentage of the rateable value, such as 20,000. I suggest 135%. For instance, if the rateable value is $20,000, and if the flat is cut into different SDUs, then the maximum rent, the aggregate rent should only be $26,000. And I think that will generate sufficient profit for the landlord. If 1.35 is not good enough, and if the government thinks that this proposal may be counterproductive, then we can discuss another level of initial rent. And for bed spaces, I think it should be different. In 2001, I stayed in a bed space apartment for 2 days, and back then the market rent for 11-year-old rent is $15,000, and then for an upper bunk bed space, I had to pay $1,350, and for the lower bunk, $1,265. So the unit rent per square foot was $70. So the landlord there could receive $75,000 in rent and total per month, and or $37,500, and that is already 2.5 times of the market value. And if all the spaces are let, then it's 5 times the market value. Alright, you had to spend more than $1,000 on one bed space. That was outrageous. I think we were exploiting those singletons living in bed spaces. So we must regulate. And because the bed spaces are very small, there was only a little room for us, for cooking, for washing, etc. So the initial rent could be a little bit higher than the as a percentage to the market value. So I say it should be 1.3 times of the rateable value. If you think it is 1.5, that is acceptable. But for bad spaces, there is no reason why it should be as high as 5 or 6 times. So I'd like to hear the administration's response. Well, to be fair to other members, you have overrun a bit, and I will only allow a very short reply from the administration. All right, a very short reply. On the question of initial rent, as mentioned previously, it's not that the government would give no consideration to setting an initial rent. It's just that given that we would like to roll out a practicable set of regulation for SDUs, then prior to having real data on the rents and also the distribution of SDUs in the market, now we require all landlords to submit such information to the R&V department as soon as tenancies are signed. And then when we get hold of such data, we will analyze them, and then we will decide whether we can further the current regulatory measures. Regarding rateable value assessed by the LVD, of course, at this moment, I will not rule out any possibilities. This is one possible option should we decide to set initial rents. But for the time being, I suggest we start with this bill first. And after a few years of operation, and we'll see whether then lack of an initial rent is a major loophole in the bill, then we can enhance the regulation. And then we also have to comply with the basic law where there is protection for private property, and we have also have to pass the proportionality test. And whether the proposal from Mr. Tian can comply with these requirements, we will have to consider the details. Well, we have quite a number of members waiting to ask questions, and we've already had a 2-hour discussion at the last meeting. So members, please to ensure that you leave time for the administration to reply, and each member will have up to 5 minutes. Mr. Tony C., of course, the bill is well-intentioned, but then it is still a far cry from expectations in the community. And of course, SDU tenants would want the rent to be affordable. And members are of the view that if you cannot fix the initial rent and you only introduce a cap on future rent increases, then it is not really very helpful for those living in inadequate housing. Of course, they don't want to be ripped off by their landlords. And I'm afraid the bill fails to achieve this objective. Well, we want to take care of the interests of landlords and to help tenants. Now, the administration's reply is that it is undesirable for the rent per square foot of SDU to be much higher than their counterparts. So why don't you fix a reasonable initial rent while you cap their future rent increases? You should also fix an initial rent to ensure that landlords' interest will not be undermined, because some of the SDUs may not comply with fire safety or building requirements, and some of them do not have the building permission for subdivision. All right. Very often, I don't know the proportion of SDUs in industrial buildings. And I think these are more dangerous sites for SDUs.
問好簡單，政府會唔會接受或者容許
？Would the government accept SDUs in industrial buildings? Of course, you would say that this is not allowed, but when it comes to law enforcement, there are about 240 cases per year. So in terms of the enforcement actions on SDUs, how many of them belong in industrial buildings, and what would be the reprovisioning or rehousing arrangements for the tenants? The Rating and Valuation Department would set up a new 50-strong team for law enforcement. So would such manpower be deployed internally? And I'd like to know the annual costs associated with this new unit. That way we can have an idea of the costs incurred as a whole. There are two conditions under the control. First, the units as defined by the deed of mutual covenant, and the unit defined by the building plan of the buildings department. Does the rent agreement have to specify domestic use? Is this a necessary provision in the agreement? Thank you. Mr. Chair asked about the number of units in industrial buildings used as SDUs. According to our consultancy study, they estimate the number at more than 6,900 such SDUs in industrial buildings. So that is an estimate according to the study. In our reply to members, we shared the enforcement figures of BD from 2016 to 20. There were about 1,196 cases, including SDUs in industrial buildings. From what we understand, when taking enforcement action, they would work with relevant departments such as the HAD and SWD, and there are also residents, social workers under the departments, and affected residents would be registered during the enforcement action, and if necessary, they would be referred to relevant departments who would help with the rehousing. Under the Community Care Fund, the residents or the funds would be made available for residents living in SDUs in industrial buildings if they are to be relocated. Ex gratia payments or subsidies could be given. For a 3-person family, there would be a subsidy of $9,000. 4 persons or above, $13,000. And this can help fund the cost of reprovisioning for the affected residents. Mr. Ronnie Chan, I asked a question at the last meeting, but it hasn't been answered yet by the government. Some people asked whether there would be an initial rent, but for different reasons, the government would not be entertaining this idea. For SDU rents, the rent per square foot is particularly high compared with other units. Why can't we impose a ceiling on the rents per square foot for SDUs? if you say that $70 per square foot is too low, you can set it at $80 or $100 per square foot. I wonder why this proposal is not entertained. Is it because it goes against the right of ownership, or it doesn't pass the proportionality test? The rent control seeks to protect vulnerable groups or individuals. Some people might rent multiple SDUs, but if we are to protect the vulnerable groups or individuals, should we impose a cap on the number of SDUs to be rented per person? Let's say at 2 or 3. Some people might rent 10 SDUs. I think we should not be providing security of tenure for these people. We visited SDUs that were referred by non-profit organizations, and the tenants learned how they could sign an agreement, but for certain vulnerable persons, they do not know about the regime, and they could be exploited by landlords. So how can we educate all vulnerable groups on this new arrangement so that all the 200,000 odd SU tenants would know about the arrangement? First, it is not that the government does not want to consider the idea of initial rents, but at this stage, we want to put in place the regime as proposed under the bill, and by the time we have official figures and having considered the operation of the bill, we will consider the way forward. Mr. Tian suggested using the rateable value as stipulated by the RVD. Another option is to impose a ceiling on rents per square foot. I believe that these are all viable options, but like I said, we are collecting the relevant data. If we establish an initial rent for some 110,000 SDUs to establish a fair level for both tenants and landlords is not an easy task, because each SDU is unique, and there are different factors such as location, and within the same building, different units could be of different values. So this is another difficulty in drawing up an initial rents. But in the future, if the government is to regulate initial rents, these are all factors we have to consider. And whether some tenants might rent more than one SDU, I believe such scenarios do exist, but we do not think there's a substantial number. For instance, the wife and children of a male tenant might be living in the urban areas, and he might choose to rent a bed or SDU somewhere close to his workplace. So it really depends on the needs of the tenants. And it's not fair to only offer security of tenure to only one of the SDUs rented by a person. For units rented for non-domestic purposes such as warehouse, but according to the bill, only SDUs used as a dwelling would be subject to security of tenure. In terms of educating our target beneficiaries on the fine print of the bill, this is indeed important. the RVD will set up a 50-strong team in the first year to engage in promotion and law enforcement. We will also provide a hotline to answer questions and provide mediation services for rental matters apart from RVD. We will engage NGOs on a district level to provide outreach service in order to educate tenants and landlords. That way, they would know their rights and obligations under the bill. Mr. Tommy Chang. Chairman, I have a very simple question. The bill is about SDUs and low-income groups, but now the scope is very wide. I asked whether the government would amend the bill, but nonetheless, I will be proposing amendments. In their answer, the government said that even non-low-income individuals would be subject to regulations so as to not miss anyone. And in my 21 years at LegCo, I've seen plenty of such examples. The government simply wants to gather enough votes, and they are using a catch-all approach to regulate everyone. They are casting their net very wide, and they simply want to gather enough votes, and this is something I do not want to see. So once again, I stress that the Liberal Party supports rent control on SEUs, but it does not mean that we support the regulation of all types of rent. There's a definition to SDUs. For low-income groups, we can have another definition. I don't think the government is really addressing our concerns. So I would just say that I will be proposing an amendment. And the amendment will be ready very soon. I do not own a single property. Even the property I'm living in do not belong to me. Let's say someone owns a unit in Central with a living room and 3 rooms. Let's say all my children have moved out. If I rent out a room or 2, then some people might be interested, since the unit is close to their workplace, and now this kind of tenancy would be would come under the regulation. And in my amendment, I would propose that if I rent out a room to one family and not more than one family, I think this type of tenancy should be excluded from the bill. If I have 2 rooms and I rent out both, well, this is not what I'm describing. Let's say I own a unit and I rent out a room to one person or household. It could be a 1-person household or 2-person or 3-person. They could rent 1 or 2 rooms, and these are 2 separate single families. So I would be proposing this amendment in such manner. I don't think the government needs to reply, and I do not think they would address it anyway.
So Mr. Tommy Cheung is going to move an amendment, and I believe Mr. Cheung will let us know the details later. Any response from the officials? Thank you, Mr. Tommy Cheung, for your view. Let us reiterate that we do understand Mr. Cheung's concerns. The purpose of the bill is to help grassroots to give them tenancy safeguards. And let me supplement here. Mr. Tommy Cheung's proposal may give rise to technical issues. For instance, if there are two tenancies and then one suddenly withdraw, and then will the remaining tenancy be exempt, continues to be exempt from regulation? We don't rule out the possibility that even if a landlord rents out just only one room, he can be overcharging the utilities, fees, and etc. All right, we will consider Mr. Tommy Cheung's CSAs in detail later. Mrs. Regina Ip, members raised the point of initial rent, and Mr. Tommy Cheung mentioned the renting out of a room. Now, we have to sort out the definition of subdivided unit. I thank Mr. Chen for explaining to us that the crux of the matter is the definition of unit. And then according to Mr. Cheung, it will be what is shown in the original building plans, or what is referred to in the DMC. Now, for instance, I've just recently been to Shanghai. In a flat, there were 10 subdivided units. So that is splitting the original flat into 10 units. But the case referred to by Mr. Cheung is, now I live in a big apartment. I cannot use all the space, and I rent one room to a university student. So I have not really split the quarter or the unit. I'm just renting out a room, and I don't think Mr. Cheung's CSA is needed. And then overcharging of utilities fees. Now we're talking about those who are living in a very inadequate accommodation. When I was a kid, there were many people renting out their rooms because back then units were much bigger. And then there is also another definition issue raised by our legal advisor. What they are just cubicles and they haven't been split up. Are they included? I don't think they should be included. I think you are talking about splitting a unit, splitting up a unit. If I haven't removed the original partitions, I just rent out a cubicle, and also bed space apartment ordinance. Now, if the partitions are removed, and would that be covered by this bill? I think you have to sort out the definition first before we can continue our discussion. Thank you, Mrs. Regina, for raising this. This is very important. One of the biggest challenges we face in drafting the bill is to come up with the definition for SDU. Now, subdivided units. I think there's some misunderstanding here. Now, even if we follow a building plan, the plan may not show the original layout of the unit, whether there are 3 rooms or 1 sitting room. Now, we're only saying that it is shown in the building plan that it is a separate unit, or it is shown as such in the DMC. We don't care about the internal layout of the unit, because in many building plans, a unit may not show the layout. It is just shown as one big single unit. So for the definition of SDU, means premises that form part of a unit of a building. I don't care whether it's only the kitchen or the toilet or room, altered or not rented out, or whether it can just be a space with a bunk bed or a bed placed there. They will all be caught by the bill because this will ensure the widest scope, because this is in response to public aspirations for tenancy control of SDUs. What about cubicles? For sure, we'll be able to cover those living in bed spaces or space capsules, rooftop house or terrace house now, or podium house, whether the whole podium or just part of it has been rented out, it will still be covered. Whether there's been any alteration is not our consideration, because we have seen many SDUs rented out in old buildings, and if you look at the plans of these buildings, you'll not be able to see the layout, whether there are the number of rooms, etc. What about cubicles with no alteration in the structure? For instance, bed spaces as defined in bed space ordinance will be covered. Yes, now I haven't read as many building plans as you have. I was thinking that building plans would show, for instance, one sitting room with 4 bedrooms. Perhaps you can show us some building plans in the future. Thank you, Mr. Vincent or Mr. Kwok Wai-keung. Many members are concerned about the issue of initial rent, but the answer from the administration is devoid of content, because I think the administration understands the challenge involved, but it's because the market is distorted or even manipulated that we need government intervention. There are a few questions. So regarding the cap of 15% in rent increase, I'd like to ask whether the administration has discussed how there will be no abuse of this 15%. Will landlords take advantage of the cap and raise rent up to 15% as a result? And also there is the question of overcharging of utilities services. Now, there is this requirement that the aggregate or total amount of utilities fees charged should not be over the actual amount paid by the landlord. But I'd like to know the time required for conducting an investigation should there be an allegation of overcharging. Because we have this problem now. Many SDU tenants feel that they have no bargaining power against the landlord, and if they dare to report such malpractices, they do not gain anything. The 3 tiers of fine will go to public coffers, so SDUs have little incentive to come out to report overcharging. They might rather pay another several tens of dollars, knowing full well that they've been overcharging. So I'd like to know whether there is any compensation. Now, the idea is not to encourage them to report, but at least after reporting such malpractices, the loss can be compensated to a certain extent. Mr. Chen, first, the 15% is just a cap, and how we can ensure that landlords will not raise rent up to 15%. Let me say that this is an additional safeguard. After the first term's tenancy, the extent of rent increase will be subject to the percentage change of the rental index in respect of all classes of private domestic properties published by the RVD. If we look at the changes in the past couple of years, they were never near 15%. In 2020, now compared with what it was 2 years ago, it was negative 6%. So rent reduction was called for. So 15% is an additional safeguard. If the market was particularly volatile, for instance, in our paper, we introduced a table in a particular in some years, the percentage was up to 30%. When that happens, the 15% cap will come into play. Even though the percentage increase announced by the RVD is very, very high, at most the rent increase can only be 15%. So it would be very rarely can for the landlord to introduce an increase of 16%. I think there were only 7 years during the period from 1998 to 2020 when the percentage change was over 15%. Now, because of the 15% cap, the landlord will not be able to make it higher than 15%. And in other times, it was usually lower than 15%, and it was a negative figure in some years. There were 9 years, in fact, out of the past 20 years. And as for electricity charges, we made it very clear that the landlord must follow the electricity bill. The landlord will have to show or let all tenants in the unit to see the electricity charge. Let's say is $1,000. If there are 4 tenants, then the apportionment should be agreed on when the tenancy was signed, whether it should be or should it be a simple apportionment, or should it be on a per head basis. The landlord has to work out the utility or electricity bill according to the agreement in the tenancy. So if it is to be evenly divided among the 4, then each will have to pay $250. Should there be a dispute, a complaint can be made, and when necessary, a ruling by the court will kick in. As regards the time required by the tribunal to make a ruling, it's hard for me to say on their behalf. But with such a clear arrangement, I believe it would be not so easy for landlords to overcharge the utilities fees. Now, if it is ruled by the court that there has been abuse, we have penalty terms in the bill. And I believe the amount overcharged will have to be refunded to the tenants concerned. Although there are going to be penalties, honestly speaking, the tenant who lodged a complaint may not be allowed to stay on. It's not just about a few tens of dollars refunded. So you don't encourage tenants to complain, right? Well, the fact that a tenant has lodged a complaint should not impact on his security of tenure. A landlord cannot evict tenants as a result. And there is also the tenancy security of 2 + 2 years.
Mr. Abraham Shek. I support the bill. This is better late than never. The bill will help low-income tenants to improve their livelihood. But can the bill achieve this legislative intent? From your answers, I believe the answer is no. You are using the proportionality test under the basic law, under 105. As Mr. Tian pointed out very clearly, in terms of rateable value, it's 1.2 or 1.5 times. I think this has passed the proportionality test. We are talking about tenants with very little money and people who are waiting for public housing. 7 years and 6 years makes 13 years, and it's impossible for them to afford rising rents every year. When Mr. Carlson Chan answered Mrs. Regina Yip's question, you talked about a lack of building plan, but according to town planning standards, population of each district is taken into account. The planning standards govern the number of schools needed, GIC space, etc. Mrs. Yip asked an excellent question. When I engage in urban renewal work, we came up with a 700 square foot unit to house 20 people. I think this is a very poor idea by those who only think about profit. My fellow legislators have voiced this issue. Mrs. Yip asked, or rather, she suggested you to adopt the standards in terms of the number of bedrooms. You are now drafting this bill to create false hope for the people, and they would simply suffer even more. When you answered Mr. Chair's question, you said compensation would be given. There's unwritten or written law in Hong Kong that nobody is rendered homeless. Even if you give people a few $1,000s, it doesn't mean that they will no longer be homeless. The Hong Kong and Macau Affairs Office has already set a target on when you have to tackle the housing issue. We have to eliminate cage housing and SDUs by a certain year. We have a legislative intent to the bill. It's about execution. You cited various difficulties. You should collect more data of people who are suffering. And then you should come up with some proper legislation. Legislation should seek to improve the living environment for these people. I support any amendments to the bill. As Tommy said, many elderly people do not wish to apply for CSSA they can rent out a room that would really help them, and now they would fall under the net. We represent different sectors. I represent real estate. I know that many people are being deprived, so we have to help those who are living in caged houses or subdivided units. I don't need an answer from the government. Next, Ms. Yuan Xiong. Chairman, I think there's a need to clarify the definition of an SCU. And people who simply rent out a room would be subject to regulation. Do we really want the scope of regulation to be so wide? What would be the definition of an SDU? According to the paper, you said we have about 110,000 SDUs in Hong Kong, but I believe the actual figure is way beyond that if we include those who rent out a room for rooftop space cabins, etc. They are all considered SDUs. So I am quite concerned about the enforcement of the law. I think we all want to help the grassroots or people who are suffering the most. For landlords who rent out a room in their flat on Robinson Road would be subject to regulation. Well, I think we should focus on helping the grassroots. The RVD would set up a 50-strong team, and they have to manage millions of units. So how could this be done? And they are going to receive a lot of complaints, and they will see a heavy workload. So shouldn't we clarify what the definition of an STU is, or does it only cover units with a minimum, certain minimum number of rooms? And how can the task force help those who are suffering the most? Secretary, thank you. In our supplementary paper, we mentioned that according to a survey, there are some 110,000 SDUs, and according to the 2016 thematic survey, there were about 109,000 SDUs, and according to the definition, we have about 110,000 SDUs, and the number of cubicles is about 3,415, and we believe that the bill can achieve our policy intent. Of course, we want to help these tenants, or about 300,000 tenants living in 110,000 SDUs, but the definition is so wide that it covers it could potentially cover millions of units. According to the bill, all these units would come under control. Mr. Tommy Cheung will propose an amendment to only regulate units with partition or structural alterations. I think the legislation is simply unenforceable. The government does not want to legalize SDUs, and they do not require the landlords to register the units. This is simply dealt with under the RVD. You are asking the grassroots tenants to report their landlords for overcharging, but they will no longer be able to live in the same SDU. So they are very concerned, and could you really provide mediation services in terms of the enforcement of the policy? Are you really helping the grassroots? the concern is that the definition of SUs is too wide, leading to enforcement difficulties. According to the latest figures, there were about 119,000 SEUs, including rooms leased out in a unit. All these rooms, or the so-called multiple households in a unit, these have been classified as cubicles. And we asked the CSD, and according to a consultancy study last year that was commissioned by us, we wanted to find out whether rooms would be let out from housing units in well-off private properties, and we learned that the situation was very uncommon. And some people are concerned that millions of units could be subject to regulation, and we can say with certainty that this is not the case. So we believe the number of SDUs is about 110,000. At the last meeting, if tenants want to operate SDUs, they would convert a unit into multiple SDUs instead of just let out a single room. Enforcement is indeed a great challenge. We can never underestimate the challenge. Since we ended the previous rent control regime in 2004, and the RVD doesn't have the manpower for this exercise, and that is why we must set up a dedicated team for this work. This is something we must pursue seriously, and we also invite NGOs to do lobbying at the district level, and this is part of our exercise. Ms. Darley, Chairman, the legislative intent of the bill is very clear. That is to help the most needy people. We have discussed rent control for SDUs for quite some time. I'm concerned that once the arrangement is implemented, it will still fall off expectations of SDU tenants. The government decided not to establish an initial rent you did not have a policy objective to maintain the level of rents at a reasonable level. Your only intent is to restrict the rise in rents. So you know the owners would counter by charging a higher rent at the first place, and the rents to income ratio for the tenants will remain high. I'd like to know your justifications. We all want to help the grassroots, but your approach does not appear to be very effective. People are still paying very high rents, so their burden remains heavy. And the national leaders are calling for Hong Kong to phase out cage housing and SDU. So policy-wise, are there any plans to achieve this goal?
Mr. Chen. Perhaps I should try to take the first part of the question. As explained, the task force in considering whether the initial renter should be regulated, and if so, how, well, there was a very thorough discussion. The conclusion was it would be very difficult to regulate on the initial rent because according to official statistics done by the our Census and Statistics Department, they would mainly cover tenancies of a single unit. For SDUs, we don't have any official data. We have done surveys, and the task force commissioned a consultancy to do a survey, but then they were not official figures. Without such basis, it would be hard to come up with an initial rent that can take care of various aspirations and considerations. As I've said a number of times, and I'm sure members understand, that even in the same building, the rents of different SDUs would differ depending on the internal decoration, the facilities available, and the orientation. Even in a same unit with 4 SDUs, the rents can be very different. And so what basis can we use to establish an initial rent? And then there is also the basic law to protect property rights. And members may think whether by establishing an initial rent we may be able to substantially lower rents to an affordable level. But then we have to take care of the need to protect private property rights. And we'll have to see whether we can pass the proportionality test. All these have to be considered very carefully. And as I stress, it's not that the government is unwilling to fix an initial rent, but as a first step, we must mandate landlords to provide us with information on tenancies, and after that we will have a solid foundation for furthering our regulation. So the proposals from members are feasible, and at least they can be further explored. Chair, just a very simple response. The administration is worried that it cannot come to a consensus on initial rent given that there is no information. Now, your purpose is to lower the initial rent, so even if you have got a lot of data, you would find it hard for landlords to agree to a reduction in rent. So it's not a question of whether you have any data or not. Even with, it would be hard to achieve a consensus. After all, it is the government's decision. The task force only give you advice. You should not put them on the spot. Of course, I respect the views of the task force, but it is for the government to decide ultimately. And of course, we all want to have a start, and of course no one will oppose. You have done a lot, and then SDUs are paying unreasonably high rent because the median rent of SDU is already very high, and you still allow landlords to raise rents. Now, unless there is a substantial increase in market rent, otherwise what you propose here is not going to help them a lot. Well, we have to admit that there is no perfect solution. We want to introduce the bill to address the problems faced by SDU tenants, but we won't say that this is a perfect solution, because there are objective factors and constraints, including constraints in the law and the protection of private property rights enshrined in the basic law. If we can pass the bill, then we can achieve at least a few things. First, landlords cannot raise rents substantially or drastically in the future. They have to follow the market trend. And if there is drastic change in the market, and if the percentage change is very high, we have the cap of 15%, and the bill also offers a security of tenancy. Members asked why can't that be longer? Because we have to consider private property rights, and if the terms are too harsh, then we are worried. Regarding the term of tenancy and also the extent of rent increase, if they are too harsh, then they can be a disincentive. So even if a very small proportion of landlords, let's say 3%, withdraw from the market subsequently, that can be a major impact. And we are concerned about overcharging of utility fees, and we have provisions to regulate that. So we believe to a large extent the bill can address some of the most pressing issues faced by SDU tenants, while ensuring that the rights of landlords will not be encroached on out of proportionally. All right, I have a few questions. The administration is not going to fix an initial rent, so rental increase is a concern. And SDU tenants would like to know whether they can benefit from the bill. We hope the cap of 15% can be lowered to 10%. Because the current rent is already very high, and we want to keep rent increase to a lower level. And as said by the Undersecretary, while no initial rent can be set up today, I'd like to know whether after information is available, if you have information for 1 whole year, can you reconsider the situation and set an initial rent? And DAB has also put a number of questions to the administration. We've yet to receive a reply, and we would like to know when we can have a reply, because the questions involves the policy itself. And then we spend a lot of time discussing the definition of SDU, whether it be Mrs. Regina Ip or Mr. Tommy Zhang. Our concern is how wide the scope can be. Now, for cubicles and also space capsules, etc., they may not be incorporated into the definition. How can you ensure that the community understand the definition? I think the government should still spend time explaining to the community. And then the Secretary has not addressed the point raised by Ms. Starry Lee and Director Xia Baolong's statement that we should say goodbye to SDUs in the city. Can you tell us the long-term goals, please, and the next step? Thank you. We are determined to resolve the problem of SDUs. I think the only solution is sustained increase in land supply. So we are trying our very best to help grassroots families to be given adequate and affordable housing. In last year's long-term housing strategy, we announced that there would be enough land for developing 360 units in the coming 10 years. And we've already identified land for more than 1,500 units, and then we will expedite our efforts. so that for public housing, we can use public housing to improve the living conditions of grassroots families. And as for setting an initial rent, we have to gather more data. We will closely monitor changes, and we will respond with appropriate measures promptly. Now we have already received the questions from the chair, and we will provide replies as soon as possible. And as for the definition of SDU, we heard now loud and clear members' concern over the definition. We will explain to the community more. On the one hand, we want to protect the tenancy security of our grassroots members, and then the most important part is how we can enhance protection for grassroots and how we can have a legislative tool for us to do that. Thank you. 4 members have raised their hands to ask questions in the second round. Now it is already 3:40. My suggestion is we spent 2 hours in the last meeting, and together with the hour today, I think we have had a thorough discussion of the bill. Now I will give members in the round of questions, and let's see if we can start our cross scrutiny today, if not next meeting. 4 more members, Mr. Michael Tan, Mr. Tony C., Mrs. Regina Ip, and also Ms. Starley. Thank you. 11 years ago, I spent 2 nights in the lower bunk space. I spent 1,300. The monthly rent was $1,350. When asked how I felt, I said that it was probably the biggest failure of the SAR government. So I'm never happy with this, and I've always asked that something be done to regulate SDUs. So at long last, the government has decided to do so, and my wife told me one day that, well, you have succeeded. I said, well, don't be so naive. Do you think the government will listen to the pressure of legislators? If the government has the will, it would not have waited until the last year of this term. Now, it is probably not because of the appalling situation of SDU tenants. My wife asked then, how come they're finally taking action? And I told her, haven't you watched the news on TV? It's because the central government has demanded that the SL government do something. Now, my worry is if I press too hard, you may withdraw the bill, and then we're left with nothing. But if you insist on having your way, then the bill will be useless. Actually, Mr. Chen, I always appreciate your performance. Now you're saying that you want to ensure that you want to improve the conditions of SDU tenants, but you have to collect data so as to look at the extent of distortion in rental value of SDUs. So the only purpose is to ensure that landlords who are profiteering will not continue to profiteer further in future. And I don't know what's the point of your bill if you can't do this. All right, if you have found out that the bed space that charged $1,300 per month is now $2,700, so it is absolutely out of tune with the market value. So I have said this a number of times. The market is always there. You talked about people's private property right. Now, if you are so concerned about this, you might as well not introduce this bill, because you are now halfway through. And you talked about the different rents of SDUs in the same unit, some with better interior decoration. Then you can fix a certain percentage. It can be 1.3 times of the rateable value or 1.7. It should not be 2 or 4 times the rateable value. Now, if we can lower the rent by $700, that means a tenant can have an extra $20 on food as a result of rent reduction.
You can determine the factor rates are an agreed indicator. I think that is the fairest standard to use. You can use a factor of 1.3 or 1.5, then you can eliminate the problem. Many people ask, or they said they don't know what is going on at LegCo. If there's no initial rent in this exercise, all the SDU providers or landlords would simply raise the level of rents right now. So by that time, when the legislation is in force, the rent levels would be very high already. This is not a piece of legislation subject to negative vetting. This is a protracted discussion. If you do not include the element of initial rents, then you cannot achieve the desirable results. If you do not stipulate initial rents, people would start afresh 4 years later. I'm talking about the aggregate rents of different subdivided units within a flat, or the rent value of the entire apartment and the multiplication factor. Some you can charge more for some SDUs and less for others. The concerned groups are not they do not have a preference of the factor at 1.3 or 1.5, but without an initial rent, the exercise will be meaningless. So hopefully the government could assess the situation. Mr. Tony Chair, thank you. The intent of the bill is to help SDU tenants I think this bill is rather ineffective or insignificant. What is meant by reasonable market rents? These are SDU tenants with very little bargaining power. The level of rents they agree with the landlords could never be fair. Well, speaking from a professional perspective, we are looking at market rents and whether it is reasonable. Why can't we establish a reference market rent? So you can have different levels in different districts. we are talking about tenants with very little bargaining power, so they cannot negotiate with the landlords. If the owners feel that the level of rent stipulated is not reasonable, they can go to the lands tribunal for an amendment. But that is how you can help people who need help. And now the tenants will continue to suffer, and the level of rents might have gone up because of this exercise. So I think this is not a job well done. In terms of the new team of 50 staff, I'd like to know how much it would cost for the government. Members offered different views on the scope of the bill. And according to the government, it is based on the deed of mutual covenant. In other words, small houses would not be subject to regulation. I'd like to know whether SDUs are commonplace within small houses. So if they are not brought under control, many people would convert small houses into SDUs. So in the future, the small houses would not be subject to regulation. Mr. Chen, let me address the second question. Small houses have no building plans, so they are not subject to control. As to whether SDUs exist in small houses, according to our communication with the building department and Lands Department, the situation does exist, but it's not very commonplace. People who live in village houses are often looking for a bigger living space. Without a building plan, it is hard to define whether there is subdivision, so this type of properties has not been included. According to manpower deployments of the new team at RVD, I would defer to the RVD. We need to hire extra staff, and there will be internal deployments as well. What is the cost associated? In the 2021 to 22 financial year, the cost is $7 to $8 million, but this is just a preliminary figure. We will come up with a more accurate sum by the time we recruit. You should have an idea what the 50-strong team looks like. The RVD has a lot of valuation offices. One kind they compute market rents. I think this is possible even with a small sample size. Well, I can do it if you ask me to do so. For SDUs, many of them lack building plans. If we are to conduct an assessment, we need some information. Once the ordinance comes into force, we will collect more information from the landlords. Is this something you can do by yourselves? Well, many SDUs are somewhat non-compliant in some way. So you should have some data available. You have talked about regulating rents for SDUs for years. It's simply that you are reluctant to act. I think there is no violation of the basic law. We are just assessing what reasonable rent looks like. Next, Mrs. Regina Yip. What is the manpower cost? $7 to $8 million. Is that for recurring expenditure? Yes, for the current financial year. Chairman, I have 2 points to make. Mr. Chen said the number of SUs is about 110,000, including cubicles or rooms rented out. Some owners are renting out one of their rooms to make some extra income or to have some companions in the house. I think this is rather common for university students. So is there really a genuine need to regulate this type of property? There aren't many of them. Our policy intent is to help those who are suffering the most. Many members talked about an initial rent. They are concerned that landlords would raise the level of rents before the ordinance comes into effect. We visited many SDUs, and the rents depends on many factors such as the facilities, the presence of windows. But if you are willing to do something, you can. In some places, there's an eviction ban and rent ceiling. Because of COVID-19, new legislation was passed, and landlords cannot raise rents or terminate the tenancies. So you should be establishing an initial rent that must remain unchanged for the first 4 years. I think your 15 factors or justifications do not stand. The government must intervene now because the market is not functioning. If the market is not functioning, the supply and demand will be out of balance. The grassroots have no choice but to pay high rents for an SCU. That's why we must intervene. The RVD collected data on rent levels for different types of properties. It's meaningless to cap the increase at 10 to 15%. The government must intervene. You can set a cap at whatever level you want. I don't think any owners of SDUs would be discouraged as a result, because they would still make a lot of money. It's just that they might make a bit less than before. Well, even if you set a cap at 15%, they will continue to provide SCUs. I think you are being too bureaucratic, and this is really out of touch with the reality. Mr. Chen, I will address the first question. For units with one room let out, we have about 3,400 units or 3,400 cubicles, and these would include typical cubicles or units with one bedroom lease out. So the figure is 3,415, and this includes cubicles and rooms for rents. At the survey last year, our consultant indicated that they did not encounter or come across many such cases, and they would be classified under cubicles.
For members, please note that now, of course, we have to look at the details of Mr. Tommy Zhang's CSAs. Now, if we exempt a unit that only rents a room out, you have the following risk. Because the tenant may be a subject we want to help. It can be a low-income household that cannot afford better housing. And there will be no regulation on rent increase and no protection of tenancy of tenant. Perhaps the household will be asked to leave within a very short period of time, and there may also be overcharging of utilities fees. And so this tenant should be among those we want to help. Can a unit be exempted simply because the unit only has one room rented out, whereas for another unit next door, the tenants are protected because there are 2 rooms rented out? And take the example of a rooftop house or a room on the podium. Now, if there is only one single rooftop house, there is only one tenancy, and then it will be exempted for an SDU on the podium. Perhaps there is only one SDU, and then it may be exempted under Mr. Zhang's proposal. We have considered all these different scenarios in our discussion. What we are seeking is to have the biggest common situations, common factors. We would like to make the scope as wide as possible and to help as many low-income families as possible. There are people who cannot afford one whole unit, and they are low-income earners that can afford subdivided units. We want to help them by means of the bill. So we hope members can take this into account. Ms. Starry Lee, I'd like to respond to what the administration said just now. Now, the administration said that the government is very determined to tackle the issue of SDUs. In fact, I've served in the community for more than 20 years, and the community I serve has the greatest number of SDUs in Hong Kong. We have so many SDUs in Hong Kong to the extent that the government dares not touch them, if not for the central authorities' direction, leading to the chief executive's decision to regulate SDUs. Well, do you know how many times we have sounded a warning on SDUs in the community, the fire risks involved, etc.? I urge the administration to review its policy. I'm afraid I cannot sense the determination on the part of the administration. I am most upset about this subject since 20 years ago when I started to become district councillor in Kowloon City. You can see the SDUs can never be reconverted. We asked you to tackle that, but you refused because you knew that it was a thorny issue and it's hard to regulate private market. And now we have so many SDUs in Hong Kong. At first, they were regulated under minor works system. Now you have finally decided to introduce a bill to tackle SDU. I'm afraid this is the result of your laissez-faire policy. Now, it's just like what happened to unauthorized building structures. If you do not take action right from the start, you wait until they are everywhere in the territory, they become a time bomb. And when you ask that UBWs be removed, everyone in Hong Kong will come out to protest. And I think the same is just the same for SDUs. You should go and review your policy. What have you done in terms of regulation of SDUs? If my memory serves me, you with our persistence, you started to regulate SDU under the minor building works regime. I want to put it on record. You forced the central government to intervene, or because of the lax attitude adopted by the administration. Many members have said that there are no proper living conditions, and I'd like to put on record this view. And the second question is about protection of private property rights. I'm sure whenever you introduce any regulation, you will use the basic law. Now, we should not compare with the mainland, of course, because you have one country, two systems. But you just look at the pace of development in the mainland. Whenever there is any injustice there in the mainland, the government there can take action. I understand in Hong Kong we have a different system, but you can take reference from other capitalist jurisdictions. Now we are talking about people who have no bargaining power and from the lowest stratum of society, and they don't have any housing. So you just use the basic law as an excuse. Maybe unfair for you to compare with the mainland. What about other jurisdictions? Is it really true that we can do nothing about it and we are bound to lose in a judicial review? Have you sought the advice of the DOJ? If yes, can I have a look at that? Or is it your political decision not to touch SDUs? Understand the challenges involved. When you want to regulate SDUs, people will come out to protest. We understand that because a lot of interest is at stake. Now, if you have received such an advice from the DOJ, let me be enlightened. I'm afraid I have very strong views about this, and we should look at history. You talked about the basic law. Have you really got any advice from DOJ, or is it a political decision not to do anything about it? Well, we have this overall consideration, having gathered views from different sectors. We have come up with this final conclusion, and then we are committed and determined to resolve the problem of SDUs. When drafting the bill, the DOJ gave us a lot of input as part of the team, so we have considered this factor. I think this is a rather honest. I think it would be a more honest response to say that you have come up with this political decision after considering a number of factors. I beg to differ. This is a professional decision rather than a political one. I understand that Mr. Tony C. still has questions, so I'll give you 3 minutes. Chair, I asked about the number of SDUs in industrial buildings last time, because we do know that SDUs exist in these buildings. The buildings department very often take action against these unauthorized SDUs, because very often they are against regulations. Now, landlords and tenants are worried that if they report such tendencies, they may invite enforcement action from the buildings department. While you want to regulate SDUs landlords and tenants in these buildings may not want to report their tenancies. Have you considered this possibility? So Mr. C asked whether that would be possible. Yes, that may be possible, but there is nothing in the bill to consider the exact location of SDUs. We do not take that into account. We also require landlords and tenants to comply with the same rights and responsibilities. So after signing an agreement, the tenancy should be reported to the R&VD. The department will not use the information so collected for other purposes. It's mainly for the implementation of this bill, and the reporting of tenancies will not lead to enforcement action by the relevant departments. I hope you understand that SDU tenants are not very knowledgeable. We keep saying that they are disadvantaged and they do not have any bargaining power. So you must help them, because they may be persuaded by landlords into not following your system. So even though you want to help them, the limited help you can offer under the bill will be useless to them. And the R&VD should do something in this regard. Otherwise, the bill will fail to help this group of tenants. Thank you, Mr. Tony C. So we have spent close to 4 hours in discussing the bill. We've already discussed the policy issues. I think we should start a clause-by-clause scrutiny of the bill. And I think we should use the marked up copy prepared by our Legal Services Division. And please quote the number, the page number on the top bottom, the top middle point of the bill. And since we've only got 15 minutes left, I think we should just go to section 122AA-B. All right? Administration, thank you. So, Chair, you would like us to use the marked up copy issued by the Secretariat this morning, right? Yes. Now, when it comes to the long title of the bill, I'm afraid we have to refer to the blue bill, and that is page 3393. Bill to amend the Landlord and Tenant Consolidation Ordinance to regulate tenancies of subdivided units of buildings and to provide for related matters, enacted by the Legislative Council. So there are 3 parts to the bill. Part 1 is the preliminary, short title and commencement. Subsection 1, the ordinance may be cited as the Landlord and Tenant Consolidation Amendment Ordinance 2021. Subsection 2, this ordinance comes into operation on the expiry of 3 months beginning on the day on which it is published in the Gazette. Mrs. Regina Ip, pause. The question I asked last time has not been answered. So you're going to amend the Landlord and Tenant Consolidation Ordinance. You have you're going to add a number of things to the consolidation ordinance. Of course, I'm not asking you to do another bill because you have stalled for a long time. First, I asked that you have a proper SDU bill instead of having sections 120 AA or AAB. Well, the government once enacted the bed space apartment ordinance. And there was also the protection of the harbor bill. It was a very short one, and there's a presumption against a reclamation there. Have you ever considered using this approach?
Would you consider that for certain technical matters? Over the course of drafting the bill, we have been communicating with the Department of Justice over the best approach. We decided to amend the Landlord and Tenant Consolidation Ordinance. We have a long history of rent control dating back to the pre-war period. The last rent control regime was terminated in 2004, and this was dealt with under different parts of the bill, Part 1 to 4. For the previous rent control exercise, the amendments were through Part 4. And these involve different aspects of rent control, and they could not deviate from the framework under the Landlord and Tenant Consolidation Ordinance. So the rent or the proposed rent control regime is related to the framework under the Landlord and Tenant Consolidation Ordinance, and we hope to achieve continuity. So having considered the matter with the DOJ, we decided that the best approach is to amend the current Landlord and Tenant Consolidation Ordinance by introducing a new Part 4A. This is in line with previous government exercises on rent control. Please continue, Mr. Tony Chair. In terms of the commencement dates, can you justify the period of 3 months? Why don't you commence or bring the ordinance into force immediately? This is a highly complicated bill. Like I said, since we abolished rent control in 2004, the Rating and Valuation Department no longer had the manpower to reinstate rent control, and we must engage in preparatory work. Apart from the RVD, we want to engage NGOs for community work to educate the public, tenants, and owners on their roles and responsibilities under the new regime and the rent control measures, and time is needed for this work. For me, I have joined the government for some 30 years. I have never dealt with such a complicated piece of legislation, and within such a short time, we had to conduct a review and complete a work report at the same time, and we had to proceed to drafting in parallel. We are very happy that the DOJ has been providing full support in our work. So we managed to draft this very complicated bill in two or 3 months. And we had to plan for future operation or enforcement in parallel. for the 50-strong team at RVD, the majority might not be civil servants, so we have to spend some time on recruitment. So a 3-month period is already the shortest we can manage. The government talked about operational issues. For current SDUs that already involve a tenancy contract, certain provisions in the contracts would have to adhere to this bill, and some time is needed for negotiations. For tenancies already signed between tenants and owners, and the provisions of those tenancy contracts might not comply with your requirements. So work needs to be done, and they need to know about the provisions. Once we deliberate the relevant provisions, we would talk about the arrangements for current tenancies. If they were signed before the bill comes into effect, they would not be affected. But for owners and tenants, should they renew the tenancy, they would know what to include in the agreement, and they would know that they would be subject to the rental hike and renewal requirements. This is certainly new for both landlords and tenants. So more publicity and education is needed. And we would work with the property management or the estate management authority. They will issue guidelines, and estate agencies would have to be educated, and they need to educate tenants on the new requirements. So this is a process of education, but we stress that current tenancies would not be subject to control until they are renewed. For existing tenancies, they would not be subject to control. Some tenants might find the existing contracts unfavorable. You are imposing rent control, but existing tenancies would not be brought under control. So you have to explain this point, because some people might complain that you are not helping them. In our future publicity work, we will explain the transitional arrangements properly, and when tenancies agreements would be brought under control. We will invite district organizations to engage in such work, and the RVD will also publish pamphlets as well as questions and answers to introduce the obligations and rights. According to the tenancy, rents will be adjusted every 6 months, no matter how long the tenancy lasts. In those cases, these provisions could not be enforced, even if such terms exist. If any contract terms violate or do not comply with the mandatory provisions under the law, then the mandatory terms must be followed. And we ask the real estate agents to be educated on this, and in any case, the implied mandatory terms would prevail. Let's continue with clause 2 to amend the enactments, and the enactments specified in parts 2 and 3 are amended as set out in those parts. We now move on to part 2, that is clause 3, section 116 amended, application of this part. Clause 3 amends part 4 of cap 7, section 116 brackets 2 brackets A. Please refer to page 0001 of the marked up copy. And the idea is to exclude the tenancies under part 4 so that they will be excluded from part 4 of cap 7. The time is now 4:30. The next part is rather long, so we will continue at the next meeting. That's all for today. We received 16 submissions, and they were shared with members on July the 28th and August the 11th. The next meeting will be held on August the 24th at 10:45 a.m. We shall be meeting every week in order to complete the clause-by-clause examination. I thank all for attending the meeting.